Well, good afternoon and welcome to the Foster Swift second Wednesday lunch series. Today we have Tony Dalimonte here to talk about labor and employment law and some of the interesting changes that have developed over the past year, 6 months to a year, with some deadlines that are approaching, which are very critical in the employment arena. Tony is an attorney in our Southfield office. He specializes in labor and employment law. And from my conversations with him, I think this is all he's talked about for the past 6 months. So he probably talks about it at work and probably talks it around the dinner table, which makes him probably a real fun guy to hang around with. But in any event, welcome, Tony. We're very interested in what you have to say today. A lot of people are across every industry, given some sweeping changes that seem to be in the works with the state legislature right now as it relates to employment law. So today we generally have a 30-minute session. Given the amount of interest, we'll probably go a little bit longer today. So feel free to post some questions in the chat if you'd like. We might not be able to get to all the questions. If that's the case, we'll either answer them separately or maybe schedule a follow-up session to see if we can satisfy everyone's questions and their concerns. So in any event, without further ado, Tony, let me just ask you a couple questions today. I guess the first thing is, can you just give us a broad overview of what's going on in the legislature as it relates to Michigan's employment law?
Yeah, thanks, Paul. You're exactly right. The Earned Sick Time Act has been consuming my life over the last month and a half. We've been doing a number of these presentations, and you all care about these changes because they're important and it's going to affect a lot of people in a lot of different ways. So, in terms of an overview of the employment law changes, so Michigan's minimum wage increased on January 1st, and then it's going to increase again on February 21st to $12.48. And the tip credit will increase and sort of gradually be phased out. The other sort of bigger change is that Michigan's unemployment law has been modified, so workers now are eligible for higher unemployment benefits and for a longer period. And then the big one, which I think everyone here is probably most concerned about, is Michigan's sick leave law is changing on February 21st, 2025. I think, which we'll get into in a second. But there's a couple bills circulating the Michigan legislature right now. And so, I think, Paul, it'd probably be best if we talk primarily about the Earned Sick Time Act, what people need to know, what potential changes there are, and, what you can do to prepare.
All right, good. Let's do that then. The Employed Sick Time Act, that's also referred to as ESTA, correct?
Yep.
All right. So when we're talking ESTA, that's what we're talking about. How does it differ from the current Paid Medical Leave Act?
Yeah, so the Paid Medical Leave Act is the sick leave law that we've been complying with for the last 6 years. And if you were a Michigan employer and you had less than 50 employees, you weren't covered by the Paid Medical Leave Act. What's changing is when ESTA or ESTA or Earned Sick Time Act goes into law on February 21st, if it goes into law, all Michigan employers are going to be covered. So if you've got at least one employee, you are now going to have to provide sick leave to your employers. And just in general, the ESTA is significantly more pro-employee. There's no exemptions for temporary or seasonal workers. And there's some really strong retaliation provisions. You can get sued. There's pretty harsh penalties. So there's a lot to really pay attention to in terms of compliance. And we're emphasizing and trying to get all of our clients to pay attention that this is a big deal. You got to know the requirements and you got to make some changes before February 21st, 2025.
Can you just describe briefly what are the pending legislative changes? There are a couple of bills that have been introduced and are at committee. Can you expand upon that a little bit?
Yeah, so there's two bills. One is HB 4002, and that was the House bill that got passed from the House and is now in the Senate, and it's in committee, the Committee of Regulatory Affairs right now. And that bill is really similar to the Paid Medical Leave Act. What it does is it raises the eligibility requirement to 50. So again, if you had less than 50 employees, you'd be exempt under this proposed legislation. The other bill is Senate Bill SB 15, which also changes the Earned Sick Time Act, but in a less dramatic way. So I think there's a cap on carryover. It takes away a private right of action, so you couldn't be sued for violation of the law. But the core functions of the ESTA would primarily stay as they are now. There's lots of articles out there on comparisons between those two bills, but both of the bills are in committee right now. We don't know what's happening. Frankly, I thought something was going to happen before the new year in the lame duck session. Nothing happened. The committee is actually meeting today on SB 15. Who knows what's going to happen coming out of that committee? I think there's a lot of folks in Lansing that are, really concerned and really set on trying to get something done. But it's politics, and unfortunately, I don't have a crystal ball. I don't know if anything is going to happen. I suppose they could try to extend the date of compliance, but again, we're going to be monitoring any changes. We'll put out an e-blast as soon as something does happen, if it does. But those are the two main bills that are circulating right now.
Okay. Could you talked a little bit of referenced who was covered under ESTA. Can you be a little more explicit as to who is actually covered under ESTA?
Yes, so ESTA covers all Michigan employers with at least one employee, and all Michigan employees. So it covers temporary workers, seasonal workers, part-time workers. The definition of employee is very broad. It essentially includes everyone except for federal government employees and true independent contractors. And the reason I say true independent contractors is Leo, the Labor and Economic Opportunity Division of the state, came out and used that wording to basically emphasize that, hey, so long as you're not misclassifying your workers and you've got someone who's truly an independent contractor, no, you don't have to give them sick leave. But if you're misclassifying someone that should be an employee, then you probably are going to have to give sick leave. So it's a good opportunity to look at your employees and make sure you don't have any misclassification issues either.
Certainly, and of course, the independent contractor status, that's a whole other subject that we could talk about as well, but we're going to stick to ESTA today. Does it also include public employees like municipalities?
It does. It does. So public employer or townships, municipalities, they are going to have to comply with the law. I think some of the toughest questions on how to classify employees comes within, townships and municipalities, because you have a lot of sort of non-traditional work arrangements. But what Leo has come out and said is that publicly elected officials and members of publicly appointed boards and commissions or other public office holders aren't considered employees unless, and this is what they say, and it's clear as mud, but unless the governing entity treats these individuals as employees. So we don't have a lot of good guidance on these situations right now. It's going to be a case-by-case basis. You're going to have to look at these folks and determine whether or not they fit within the definition of employee under the statute. But I think it's going to depend on the specific situation.
We're getting some excellent questions that are coming into the chat, but let's go through hopefully we can answer some of the questions just as we go along, but certainly we'll try to get to those at the end because they are very good. How do employees accrue sick time under ESTA?
So employees are going to accrue sick time at a rate of 1 hour for every 30 hours worked. Okay, so that's the accrual rate. Use is defined a little bit differently in the statute. So there's a usage cap, and that means that you, the employer, can set how much the employee is permitted to use in a given year, use their sick leave. And that depends on whether or not you're a small business or not a small business. So if you're a small business, which means businesses with 10 or fewer employees, you must allow employees to use 40 hours of paid sick leave or 32 hours of unpaid sick leave. If you're not a small business, the usage cap is 72 hours of paid sick leave. And accrual begins, when the law goes into effect, if it goes into effect on February 21st, 2025, or whenever an employee is hired, whichever is later. So if you hire someone in April and this law goes into effect, the employee will start accruing time on day one. And again, use is capped under you can always give more, but what the law says is you have to allow employees to use up to the 72 hours if you're not a small business, or 40 hours paid, 32 hours unpaid if you are a small business. And there's ways to calculate, if you're a small business or not. The law looks at the current and previous year and whether or not how many employees you've had in the current and previous year. So you probably can't get around any sort of lowering your number of employees the day before the statute goes into effect. You're not going to be able to do that because it looks at the current and the previous year.
What about a situation where somebody doesn't work per hour, say a truck driver, for example, if they're working on a per mile basis, how is that accrued?
So that's a good question. And we've gotten that, we've had that issue come up. And so what Leo has come out and said in an FAQ is when you're determining how much to quote unquote pay an employee for paid sick leave, you have to determine their regular rate of pay. And for employees where a normal hourly wage is something other than a salary or an hourly worker, what you do is you look at the pay period immediately prior to the pay period in which the employee wants to use sick time. And you try to basically come up with an average hourly wage. So if you have a truck driver that's being paid by the mile, you're going to look at the pay period prior to when they want to use sick leave. And look at the hours worked, look at how many miles they drove, look at what their wages are, and basically come up with an average hourly wage. Same thing with sort of flat fee workers. You may not have been tracking flat fee workers, how many hours they're working previously. You're going to need to do that now so that you can come up with what hourly wage or what rate you're supposed to provide them with in terms of sick leave. So it's not clear cut for the non-traditional forms of employment, but there's ways, and Leo has come out and given us resources to help us do that. Until we have further guidance, the FAQs are really all we've got right now. So I'd say use the tools that you've got, and then you got to look at the pay periods before when they want to use it.
Okay, thank you. That the accrual sounds like an absolute nightmare. That whole issue of how they can accrue the sick time. But let's move on a little bit. What can employees use sick time for under ESTA?
So as the name suggests, employees can use sick time for them or their family members, mental illness, physical illness, or injury. So family members defined really broadly. But the purpose of the statute is to provide employees, if you get sick, if you wake up with a sore throat, if a family member has to go to a doctor's appointment, if the employee has to go to a doctor's appointment, you have to allow them to use sick leave for those purposes. I also want to point out that family member is defined really broadly, and it includes sort of close associations with between the employee and someone else. So it doesn't necessarily have to be a sort of blood family member. So those are the sort of reasons that an employee can use sick leave under the ESTA.
So it doesn't have to be a relative. It can be a close family friend.
So the language in the statute is, I think it's anyone closely associated by blood or affinity. What affinity means, I don't know. Could be a neighbor that you sort of treat as your uncle or someone that you've known your entire life. I think these are going to be fact-specific questions where if an employee came to you and said, "Hey, my neighbor that I treat as my aunt, has this medical issue. I got to go take her to the doctors. That's probably covered under the statute.
Wow. Can employees carry over the time?
Yes, all accrued but unused time must carry over on a year-to-year basis. Um, so at the end of the year, you're going to have to keep track of an employee's use of time, and how much they used, how much is accrued, and then carry over that time on a year-to-year basis. So whether or not you're using a payroll company or you're just doing it by hand, you're going to have to keep track of these hours and keep track of a bank essentially of how many hours each employee is going to have on a year-to-year basis.
And we have a 9-day deadline as it stands right now. Are there any policy decisions that companies are going to need to make to prepare in this 9 days?
Yeah, yeah. So first and foremost, you got to review your policies or draft compliant policies if you don't have one. And there's a couple really key policy decisions that employers need to make. First is front loading or providing all of the sick time upfront on January 1st or whenever your benefit year is. So an option is front loading, which is permissible under the statute, or an accrual method. So meaning employees will receive sick time as they accrue it at a rate of 1 hour for every 30 hours worked. So an employee works 60 hours, they then bank 2 hours of sick time. I think there's benefits and cons to both method. For example, if you have a temporary or a seasonal worker, it probably doesn't make sense to front load 72 hours of sick time to that employee when they probably wouldn't accrue that amount throughout the entire year. On the other hand, if you have salary workers who are going to accrue close to 72 hours, it probably makes sense to just give them that time on January 1. And these are decisions that you want to write into your policy. So that's the first policy decision. The second policy decision is whether or not you're going to have a combined PTO policy or a separate policy for your vacation time and a separate policy for sick leave. You can have a combined PTO policy. We get this question all the time. Hey, I give 10 days of vacation. Can I just lump everything into there? So what the law says is you're permitted to have a combined policy so long as you're giving at least as much sick leave as permitted under the statute. So if you gave 10 days of vacation, you'd probably want to modify your policy to say, employees can use this for vacation and any, uses specified under the Earned Sick Time Act. The problem with having a combined policy, and it's a business decision, is carryover. So you have to carry over all accrued but unused sick time. And if you have a combined policy, my recommendation would be to carry everything over that's not used out of that combined policy. Because if you don't, you're getting into a situation where you have to sort of decide what was used for vacation, what was used for sick leave. It kind of takes away the benefit of the combined policy. I think so that's the combined policy. And then the other option is just having completely separate policies where you've got a vacation policy and then you've got a sick leave policy. The only downside with having the separate is you're probably going to be providing more lead time, or maybe it's not a downside, but you're probably going to have to provide more leave time or sick leave time than you currently do under your current benefits. So those are some business decisions that folks are going to have to make as we get a little bit closer and we're 9 days out.
Thank you. What about when an employee leaves? Does the employer have to pay it out?
Don't have to pay it out. So once an employee is terminated or resigned, the statute says that you don't have to pay out any sick leave. That being said, under the Wages and Fringe Benefits Act of Michigan, that law tells us that we need to comply with our policies. So if you had a handbook that says that I pay out all of my sick leave or I pay out all of my vacation time whenever an employee leaves, and you don't change your policy, when this law goes into effect, you're going to have to comply with whatever current policies you have in place. So it's really important that you look at your policies and you know what's in there, and you make sure that you're compliant. And if you're paying out, you want to pay out, or if you don't want to pay out, you don't have to under the law. So those are some decisions that you're going to have to make.
What we touched on this a little bit, but what rate are employees paid for using unearned sick time? How is that calculated?
Yeah, so the sick time pay must be paid at the rate equal to the employee's regular rate of pay or minimum wage, whichever is greater. So it's typically going to be whatever the employee's regular rate of pay is. So if you have a salary employee, it's just as if they're taking PTO or vacation time. If you have an hourly employee, you're going to have to take that into account um, on their paychecks as if they're taking a paid vacation day. And for all those situations where it's different, or it's pay by mile or commission, again, you need to look at the pay period prior to when they want to use sick leave to come out to that sort of regular rate of pay.
What about documentation? Can an employer require a sick note or require a disability slip, or what type of documentation is needed, or can an employer request?
Yeah, so this is a big change as well. Employers cannot ask for reasonable documentation proving the need for sick leave, so a doctor's note, until an employee has missed 3 consecutive days or used 3 consecutive days of paid sick leave. So that means if an employee uses 1 day or 2 days, you can't ask for a doctor's note. If they miss 3 days, you can't ask for a doctor's note, but you're on the hook for out-of-pocket expenses associated with obtaining that note. So you could be on the hook for mileage, for any co-pays associated with obtaining that note. In terms of notice, and the question we get all the time is, can someone just wake up and not show up to work one day? Am I just going to get ghosted by employees? So you can put in your policies that notice is required in this manner. So you can require notice up to 7 days if the need for sick leave is foreseeable. So if someone's getting their wisdom teeth out, you can require advance notice. That's something that's scheduled in advance. For leave that's not foreseeable, so if someone wakes up in the morning and they don't feel well, or they got a sore throat, the law says you can require notice as soon as practicable. So that's pretty broad. I think that probably means that employees can let you know that morning if they're not going to show up to work. But that's what it says.
What about record keeping requirements for the employer? What type of record keeping requirements does the employer have?
So the employer must keep records of hours worked and earned sick time taken for at least 3 years. And you have to also post a notice on February 21st, 2025. So two aspects of, when this law goes into effect, you got to post the notice that's on Leo's website, or post the poster, and then also provide a notice to all employees, which I think is sufficient by sending out the notice to all the employees. But in terms of record keeping, it's really important that everyone complies with this, because if you don't, there's actually language in the law that says that there will be a presumption held against you that you have violated the statute if your records aren't in order. So if someone complains, if you get audited, if you get sued, and you don't have your records in order, that presumption will be held against you that you're actually in violation. So really important that you keep track of those things.
What are the penalties?
So the penalties for noncompliance are $100 if you don't post the poster and provide notice to employees. It's $1,000 administrative fine if you don't provide sick leave to employees. And there's also really serious retaliation provisions in there that allow an employee to bring a private right of action against employers. And the statute of limitations is 3 years. So you can get sued by employees for violation of this law. And the big thing is there's statutory attorney's fees. So I think this is going to be a plaintiff's attorney's dream because it's so difficult to comply with. And you can get hit with statutory attorney's fees and liquidated damages for violations of the statute. So we think there's going to be litigation when this thing goes into effect. Um, I think it's scary. The other note on retaliation is if you take adverse employment action against an employee um, within 90 days of the employee engaging in protected activity, meaning they complain about not getting enough sick time, they complain about your policies, they participate in an investigation um, with another employee about sick time. And then terminate the employee or demote them or do some sort of adverse employment action, there will be a presumption that you have retaliated against that employee. So again, very serious penalties. It's very important that everyone pays attention to this and hope that our legislature can get something done in the next 9 days.
Well, that's just it. We're 9 days away. What should employers do now to prepare? Like right
So you
now.
gotta look at your policies and you gotta draft policies if you don't have them. So what we're telling folks is prepare as if it is going to go into effect on February 21st. You don't necessarily have to put those policies into effect. Wait until February 21st, but have that policy ready. Have it ready to go on the 20th, the day before. Have an email drafted to employees with the poster on it, or print out the poster, have it ready to go. It's really just policies, policies, policies. And so that means that you need to make business decisions on front loading, on accrual, determine whether or not you're going to have a combined or separate policy. And look out for any legislative changes. We're going to be monitoring them. If something changes, we'll put something out there immediately. But those are the main things that people need to pay attention to.
What about collective bargaining agreements? Employers that employees are subject to a collective bargaining agreement. Does this apply to them as well?
It does. So for collective bargaining agreements, what Leo has come out and said is if you have a current collective bargaining agreement in place that touches on leave, so it doesn't specifically say sick leave, but if it touches on some type of leave, then you're exempt from having to comply with this law. If you don't, if you have what Leo has come out and said is if you have a CBA that's silent as to leave, or your CBA has expired and you're still negotiating, you will have to comply with the Earned Sick Time Act and provide at least as much sick time as required under the law. Um, you know, I think there's a lot of ambiguity there on, what constitutes, leave, where Leo got those particular requirements, but that's what they've said in an FAQ. So it would be good to look at your CBAs, see when they expire. If you're negotiating right now, make a determination on whether or not you're going to comply with the strict requirements of this, or if you're going to, sign a CBA before this goes into effect. So those are all decisions that you'll have to make.
Okay. Well, thank you, Tony. It's about 12:30. Let's go through some of the questions. We got about 75 of them in the chat, so I don't think we're going to get to all of them. But let me just run through some, and we'll go, for a little bit longer, and then we can follow up from there. The first one, I'm just going to go basically in order that they were posed, and the early bird gets the worm, so to speak. So one was posed at 12:03. May an employer allow employees to use ESTA for any reason and not just those outlined in ESTA? And it goes on to say, I ask because a lot of people in the workforce are going to be losing PTO vacation time as a result of employers being forced to grant ESTA. Hopefully that makes sense.
Yeah, I think that makes sense. And I think it kind of gets into what type of policy that you are going to have. So if you have a combined policy, I think it's permissible to say, an employee can use any leave time for, whatever reason, vacation, sick leave, so long as it's permissible under the statute. So if you're giving an employee 20 days, for example, and you say, you can use it for whatever you want, I don't care. I think that's permissible. Now, if you have separate banks, the employee generally has to tell you if they're going to use sick leave, so that you can, keep track and mark your bank. But I think that is permitted, that they can use it for whatever they want. The specified reasons are for, themselves or a family member being sick. So long as they're complying with that and using it for a reason specified by the statute, I think that's fine.
Okay. What about a deputy treasurer and deputy clerk are appointed positions? Are they eligible employees under ESTA?
That's a tough question. So Leo has said that if they're publicly appointed officials, they're exempt. Um, I think it would depend on how the township or whatever municipality treats them. Are they a W-2 employee? Those types of questions. I can't give a blanket yes or no because it depends and there's a lot of ambiguity in that arena right now. But I think those are that's how you should analyze it is, do they fall into one of the FAQs by Leo? Do they receive a W-2? Do you treat them as if they're an employee? Do they fall into the definition of employee under the statute? Those are things that you'd have to look at.
Okay. Are we able to front load sick time or does it have to move to an accrual basis?
You
So for
can,
example, if we
yeah.
front loaded January 1st, 2025, are we okay or do we have to add more on February 21st?
So it depends uh, what the policy says. So if you front loaded, if you didn't front load enough time, or your policy isn't compliant with the ESTA, I'd say you probably need to make a change, or provide employees additional time when the law goes into effect on February 21st. Um, it's a little weird that we've already passed January 1, so if this does go into effect, um, we have this month and a half period of limbo where you're probably doing something before or you're doing nothing because you weren't required to. And now you're going to have to start providing folks time on February 21st. So it kind of depends on your policy there.
Let me ask, this is an interesting question. And they all are, of course, but we are an agricultural business with the vast majority of employees being on full commission. This isn't a problem for the full-time employees, but we also have a few occasional part-time and part-time commissioned employees who work pretty much when they'd like. The commission employees don't track hours, and some may only work once a year or even less frequently. Do you have suggestions on how we would implement this? They set their own schedules, so no hours are ever reported.
Yeah, there's not a lot of good guidance there for those types of situations, and we've gotten those questions before. My best general advice is you're probably going to have some of these folks start tracking their hours so that you can keep track of how much time they're accruing. Now, if you have someone who's part-time, they're probably not going to be accruing a ton of time on a yearly basis anyways. If it's sparing work or, one day a month, couple days a month sort of thing. But yeah, I mean, if they were just on a flat fee or commission basis where they didn't have to track their time before, you have no way of figuring out how many hours someone is accruing without asking them to, like, hey, you got to tell me how many hours you're working now. So I think that's probably the sort of most practical advice that I can give is people are going to have to start tracking time when they probably didn't have to or haven't done it previously.
Okay, can we do one pot of earned PTO that includes ESTA, or does it have to be a separate group?
Yep. You can do it together so long as you're carrying over or complying with the carryover requirements. And my recommendation there is if you're going to do combined, you got to carry everything over.
Okay. Can we discipline employees if they use more than the allotted earned sick time under ESTA?
Um, That's a good question. I think the answer is yes, in general. So you're permitted to enforce your absentee policies and your attendance policies. If someone uses or is missing work and they have no applicable leave anymore, they don't have a, good reason not to be at work, you're permitted to enforce your attendance policies.
Okay. We got you on the hot seat, Tony. Are employers allowed to remove vacation time from employees that already have it to accommodate for ESTA?
Yeah, so generally, vacation and until now, sick leave, if you were less than 50 employees, it's up to the discretion of the employer. So under the Wages and Fringe Benefits Act, you're permitted to change your fringe benefits at any time. That being said, it can't be retroactive. So if you provided vacation time and it says that it's front loaded and someone, took a 2-week vacation in January, you can't claw back any of that time. That being said, going forward, so long as you implement your policies and making sure that, all employees are aware of any handbook or policy changes, you put those changes into effect, you are permitted to reduce vacation time if that's a business decision that you want to make.
Okay. Are employees eligible to use ESTA time accrued from day one, not subject to any probationary periods that they may have for other PTO?
That's a good point, and I didn't mention that. I should have mentioned that. So under the ESTA, you can implement a probationary period for use of time. So if you have an employee that's hired in March, for example, they'll start accruing time in March, but you can wait. You can prevent them from using any time for 90 days after the date of their hire. After that point, they have to be permitted to use the time. I would just pay attention to your policies. If your policy doesn't explicitly say that, they're under a probationary period for sick leave purposes as well, they're probably permitted to use sick leave. So I would just make sure that's very clear within your policies in your handbook.
Okay. I think I'm going to cover 3 questions with, one question with 3 chat. What about election inspectors, volunteer firefighters, or internships?
Yeah, so those folks fall under the bucket of not a lot of clear guidance on how to handle these people. So volunteer firefighters, I mean, I don't have a good answer. There's not a clear answer out there. Um, you know, I don't know if they're receiving a W-2. If they are, I don't know if the purpose of the statute was to provide sick leave to volunteers. That being said, because of how broad the definition of employee is, I suppose I could see a world in which volunteer firefighters come within the purview of the statute. That being said, you get into questions on how much time are they actually accruing. If they're volunteering on a weekly or a monthly basis. So unfortunately don't have a clear answer there. For interns, if they're paid interns, and would receive a W-2, they're probably going to be covered under the statute. They would be considered an employee. And then what was the other one? Election officials?
Election inspectors.
Election inspectors. So I don't know if those folks are publicly appointed or not, but assuming they're not, and they're providing and they fall within the definition of employee under the statute, so providing, services to an employer in that business, they might be considered an employee, in which case, you would need to figure out how much time to accrue for them. I know that's on a these folks don't work year round. So, and when they are working, it's probably a couple hours for a limited period of time. So I suppose I don't have a lot of good advice. My best advice would be to make sure that you might have to have people keeping track of, when they're working so that you can accrue. But those are unique situations that not a lot of clear guidance on.
Just a few more. Again, there's so many, and they're all really good questions. We could talk all afternoon. For the pending legislation, does 50 employees refer to the total number of people or rather full-time equivalents?
So for the pending legislation on HB 4002, it would be total employees. So it'd be kind of similar to the Paid Medical Leave Act, where if you had less than 50 employees, you don't have to provide sick leave. That being said, I don't know what the law is going to look like when it comes out of committee. If it comes out of committee, that could be something that the parties compromise on, or it could be, they scrap that bill and move on to the Senate bill. So I don't know, but in general, that's what it was referring to.
Okay. Another good question. Currently, my organization has the practice of asking employees whether they will be using sick time when they call in to say they will be absent to ensure that they are using sick time for approved reason. Would this practice be an issue, especially under ESTA?
Yeah, that's permitted. So one of Leo's FAQs is that exact question. And they have come out and said that, yes, you are permitted to ask questions on whether or not an employee is using sick leave for a permitted use and, what you're using leave for. So you can ask why someone's not showing up and, what are you doing? Are you going to the doctor's office? Are you sick? You're not feeling well? Who's sick? What's going on? Just so you can determine whether or not them not showing up falls under the permitted uses. So that's allowed.
Just a couple more. Can we pay out carryover hours instead of carrying them over?
Nope.
No?
Nope, you're not permitted to carry out in lieu of providing sick leave or in lieu of carrying over. That's one of the things that I forget which bill deals with it, but one of the proposed bills would permit paying out, I think permit paying out in lieu of carrying over. But under the current ESTA, the answer is no.
Okay. Well, I think that's probably all the time. I know people have to move on with their day, and I certainly appreciate everyone's participation today. And I do apologize. There's just so many questions, and they're all very good. And we'd like to answer all of them, honestly. So we'll talk internally about a follow-up that we can perhaps do. This session is recorded, so if somebody wants to review it, they certainly can go to the Foster Swift website and do that. But really, and we knew this topic was going to be very relevant, and we're dealing with a very short time frame. So we'll discuss internally what we can do in terms of something in the near future, and hopefully be able to get back to people. In the meantime, Tony Dalimonte, you reach out to him at his email address is adalimonte@fosterswift.com, and I think the link to that will also be contained within the link on the website as well. But so Tony, thank you very much for your time today. That was excellent, and you can go back to talking about this over the dinner table. But certainly appreciate all your knowledge and wisdom in this regard. And I appreciate everybody participating today. Our next Wednesday session is next month on Jennifer Monisser. We'll be discussing surrogacy and parenting issues. So everybody have a good day. Thank you.